Hello, am I audible?
Sir, I am audible.
Yes, yes, you are. You are.
Sir, on last class you have said that damages is required for the negligence.
Yeah, yeah, real damage.
In this case, in damages, we can count the economic loss or mental health as economic is damages.
Yes, we will discuss that. I mean, in specific cases. Don't worry. Like, see, pure economic. For your knowledge, pure economic. Losses are sometimes not counted. Okay, and sometimes they are counted. So you will come across different judgments in which there are different kind of positions. That the judges arrive at. Okay, so if you were to ask me, sir, do we have a clear rule that says that, well, this will count and this will not? Well, we do not have a very clear, rule relating to that. So you will have to rely on a chain of, precedents to identify, to substantiate a particular position. But the, general point is that, pure economic loss doesn't count. Okay, pure economic losses are not. I'm coming to that. I'm really going ahead of the topic here. Okay, so as we discuss more and more cases, the things will be clearer to you. So I hope I'm making sense so far. So, but if not, then we will as we discuss more classes, more topics. Okay. So yes, just a quick recap. So we discussed what negligence is. Okay, you are expected to show ordinary care or skill. Okay, and you do not do that. Okay, leading to a breach of duty. Okay, and then from that breach of duty, you suffer some. Someone suffers some consequential damages. Okay, so this damage is very essential. Okay, is someone being negligent, okay, without any effect of it, without any effect of it, uh, is not really problematic here. Okay, only when one suffers from some real damage, that we consider it as a case of negligence under tort. Okay, so you could come across cases of people not being careful, people who are just heedless. Okay, not every such act will count as negligence. Okay, so here it has to take the form of or either omission when there was a duty of to do something, or commission when there was a duty to omit. Okay, that leads to certain damages. Okay, but actual damages, only then can we say that this is a matter of negligence. Okay, and then we also distinguished between what is a civil and what is a criminal negligence. The difference being that one is of in case of criminal negligence, the degree is much higher and it is much more gross. Okay, it's like gross, not much more. It's gross negligence. Okay, and along with that, there's this presence of mens rea as well. So if these two things are present, then you have criminal negligence. And then we discussed about this broad ideas that we come across. Okay, one is foreseeability and proximity, and the last topic that we discussed is of new duty situation. But before that, a very important question was asked by Aditya Jha. It was very relevant for us, that when does this idea of limitation, when does the law of limitation start counting in case of negligence. Okay, so it's as I said, it's not very clear for me to answer that question here. Okay, but why? Because it's a matter of thought first, and secondly, it's simply this, that yes, generally the thing is that it will start running from when the cause of action starts. Okay, that's the point. Okay, but then in case of negligence, okay, so sometimes that the harm that you have suffered, okay, the damages that you have suffered, okay, it is in essence because of certain act, okay, certain event that had happened. Okay, certain act, certain breach of duty, okay, either through act or omission on the part of the defendant that had happened earlier. Okay, but it wasn't possible for you to know that the damage that you have suffered was in essence because of the act of the defendant. Okay, so in such case, should we say that the this limitation time, limitation period starts from the time when the cause of action had arisen. Okay, when does the cause of action arise? Okay, this is a very important question that we struggle with. Okay, so in some cases, okay, of negligence, it starts when you come to know that the harm that you have, the damages that you have suffered is big, in essence, because of the act or omission on the part of the negligent defendant. So I also gave you guys, some of you were not there, the example of, for example, an incident that had happened. Okay, take for example this leakage of poisonous gases. Okay, and then the effect of it is detected maybe after 5-6 years, and you had no way of knowing that you had suffered this harm, okay, because of that incident. So you had no way of instituting a suit, for example, within the 2 or 3 years of that event happening. Okay, so in such case, would we say that, well, yeah, you have exhausted the limitation period? Okay, it does not make sense. So in such cases, we have, so as I discussed the other case the other day, we have examples of cases where the limitation was allowed to run from the moment the plaintiff could, in essence, could trace you could know that, well, the damages, okay, that he or she has suffered is in fact from the negligent act or omission on the part of the defendant. Okay, so that's the idea. As we take more cases, things will be clearer, because at this stage when I'm learning, so as I get more cases, I'll definitely bring them to you. Now, another important topic, where the one that we left at in the last class, is the question of new duty situation. Okay, so the thing is that when we say that in case of negligence, okay, there are 3 elements. Okay, so there's one is expected to show due care. Okay, exercise due care. So one has the defendant here in case. Okay, so one has a legal duty to exercise due care. Okay, there is breach of duty and then consequential damage. Okay, now the thing is that, well, where does this duty come from? Do you find it in a statute? Well, if there is a statute, you will find it in the statute, no problem. But not every duty is laid down in a particular statute. Okay, the fact that we live in a particular community, okay, that fact in itself could lead to existence of certain rights and certain duties. Okay, certain duties that we that we claim as against others, as against our neighbors. Okay, so as I said, this law is also known as law of neighbors. Okay, so this duty that we are going to talk about, the duties that you have towards your neighbors and they have towards you. Okay, so this is the law that we are dealing with. Okay, now do we have an exhaustive list of duties which we owe each other, which we owe one another? No, we cannot possibly be laying that down. Okay, so you may find it in the form of statutes when it is laid down in the statute, and if the statute lays down a particular duty, if there is a breach of such duty, the statute also lays down the remedies that you have in case such duties are breached. In other cases, you may also find them from past precedent. Okay, other case laws. Okay, other judgments from the past. Okay, you may find the duties therein as well, but it's not necessary that every judgment that we come across will lay down in exhaustive and clear terms the kind of situations in which we owe duty to one another. Okay, it's just not the case. Okay, so I told you that even in codified legal systems, for example, the French legal system, they have only few provisions relating to law of delete, and from that, where the judges are expected to decide the matter based on the code. How the hell do the judges do that? I mean, how is it possible for 5-6 sections of a particular code will be dealing with every possible situation that might arise? So that judges have a lot of room to play. So yes, in this case, okay, in the case of negligence, okay, you will come across cases where new duty situation is required. So when we say that, we are not saying that the duty did not exist. Okay, duty already existed, Now, in the light of this new situation, because factual situation has no limits, okay, we are not constrained or limited by limited sets of physical events. There could be many different physical events that happen, and those different new situations would lead to what should I say? I wouldn't say existence, because those duties already existed. So application of duties in those new duty situations. Okay, so you may get new duty situations where the judges will recognize that the defendant had a duty. Okay, so that's the thing. Now with respect to this, as I said, there are two jurisprudential positions. Okay, one is that yes, in fact, when the new situations come, judges in fact do legislate. Okay, when we say they do legislate, we mean that judges are requiring recognizing a new duty. If they are recognizing a new duty, they are creating the law. And how do they do that? Some would say that they will take into mind the policy considerations or economic justification for recognizing a new duty situation. Okay, so some say that, whereas there are others who would have a problem with this, and they would be like, well, judges, them being not the democratic representatives of the people, okay, not being the policy makers, and not having democratic legitimacy, they cannot be making laws. So they cannot create a new duty. Okay, they cannot create a new duty, and if they at all talk about a duty, they have to justify it based on some precedents, past precedents, or some principles that exist in that particular legal system, which has been there. Okay, so they would say that the law consists not merely of rules, okay, but it also consists of certain principles that exist in that particular political community. So these are the two different jurisprudential positions that we are going to discuss later on in the classes of jurisprudence. Okay, but as of now, if you guys are clear with this idea of new duty situation, then let's take up some case laws. Okay, are you guys clear with this idea of new duty situation so far, as I was trying to explain? Did I make sense? Yeah, am I audible to all of you?
Yes, sir.
Okay.
Yes, sir.
Okay. So I'm sending you guys a link to a very important case where we will have different interpretation of this case as well, of a situation, of a case, okay, in which a new duty situation was recognized. Okay, and it's a very famous case. Okay, more famous than any other cases that we are going to discuss in this class. Okay, so I hope you are able to click on the link. Okay, it's by the name Donok versus Stevenson. Okay, and negligence. Okay, it's a very important landmark case on negligence. Okay, now you will see how the law of negligence is emerging with these important cases. So the thing is that see, you have not yet studied law of contract, but we have basic contractual ideas discussed here. Okay, so we have certain duties. Okay, so you know that in contract usually there are two parties. Okay, so yes, promisee, promisor, whatever. Okay, you have two different parties. Okay, in case of contract. Okay, one promises to do something with regard to the other in lieu for some consideration. Okay, so you have some kind of legal relation between two parties. Okay, when there is a contractual relation between them. Okay, however, there could be other situations in which there is no such contractual relation between, for example, party A and party B. Nonetheless, certain duties are recognized. Okay, duties which you may not find have been laid down in any statute, okay, or anywhere else, but nonetheless those duties exist. Okay, so this is a very important case with respect to that. Now if you see if you are able to open the link, okay, you will see the facts issues have been discussed. Okay, so it's a Scottish dispute, okay, a very famous case, okay, in English law. So it was instrumental in shaping the law of tort, okay, and it's very important even now. Okay, Lord Atkins' contribution in this judgment is very important for us. Okay, so what are the facts? The brief facts have been given here that on August 26, 1928, Mrs. Donog's friend bought her, ginger beer, okay, from this cafe, okay, in Paisley. She consumed about half the bottle, okay, so it's not clear drink, okay. So she consumed about half of the bottle, and the bottle was made of dark opaque glass, so you could not have seen what's inside, okay, what the content was, okay. And when the remainder of the contents was poured into the tumbler, okay, at this point the decomposed remains of a snail, okay, half decomposed, as we read, okay, half decomposed remains of a snail floated out, causing her alleged shock and severe gastroenteritis. Okay, enteritis. Sorry. So the glass could not be. I mean, what's inside? Okay, the glass bottle could not be seen. So she had consumed half the ginger beer, and then she put the remaining in the tumbler, and then she found that there was a half decomposed body of a snail. Okay, and that gave her shock as well as gastroenteritis. Okay, so Mrs. Donog was not able to claim here, okay, through breach of warranty of a contract, okay, because she is not the party here. She did not consume it, okay, so she was not party to any contract. Therefore, she issued proceedings, okay, against Stevenson, okay, the manufacturer, which the matter ultimately reached the House of Lords. Okay, so there is no contractual relationship here, okay, because Stevenson is the manufacturer, okay, and she purchased it from some other place, the cafe, Wellmeadow Cafe in Paisley. Okay, so there is no contractual relation between Mrs. Donog here, okay, and with that of the manufacturer. Okay. If she had bought it from the manufacturer, then you would say that, well, there is a contractual relationship. Okay. Now the question that arises in the light of this situation is this, that, well, Mrs. Donog didn't, buy the beer directly from the manufacturer. Okay. So there is no contractual relationship. Okay. So if there is no contractual relationship, would there be any other, duty that this manufacturer would owe to her? Okay, so that's the question that was to be decided. So in the issues, you can see the question for the House of Lords, the highest appellate court there, was if manufacturer, okay, owed Mrs. Donog a duty of care in the absence of contractual relations contrary to the established case law. Okay, so the established rule basically is that these duties would be restricted to what the contractual law contract, okay, contractual stipulations say. Okay, so in this particular case, the court had to find out whether there was any other duty that this manufacturer owed to that of Mrs. Donog. Okay. So this case, okay, Donog was effectively a test to determine if she had a cause of action, okay, not if she owed compensation for any damages suffered. So that's different. So let's first look at the cause of action thingy. Okay, so if you jump to the 2 points which have been discussed, okay, it says absent a contract, a manufacturer owed, okay, no duty of care. Okay, so this is what used to be the situation earlier. Okay, in previous cases. Okay, to a consumer when putting a product on the market, except two situations: if the manufacturer was aware that the product was dangerous because of a defect and it was concealed from the consumers. In this situation only, in earlier cases, the manufacturer owed duty. So essentially in case of fraud. Okay, the second one is the product was danger per se and failed to warn the consumer of this. Okay, failure on the part of the manufacturer to warn the consumer. So in this particular case, okay, it was ginger beer, so it would not fit into these cases. Okay, it was not a case of fraud. Okay, manufacturer probably didn't know or did not do it deliberately. Okay, nor would ginger beer be considered as a dangerous thing. So in this particular case, okay, the court nonetheless found, okay, by a 3-2 majority that yes, in fact, there was a duty that the manufacturer owed to the consumer. So you see in the decision part that the House of Lords found Mrs. Donoghue with the leading judgment delivered by Lord Atkin, whose views are very important here. Okay, with 2 dissenting opinion. Okay, the ratio decidendi of the case is not straightforward. Indeed, it could be interpreted as narrow as to establish a duty not to sell opaque bottles of ginger beer containing the decomposed remains of dead snail. So you know that some kind of duty of care has been recognized here. Okay. So there are many different components of the judgments which has been discussed here. Okay, first, okay, as you can see in the next para, negligence is distinct and separate in tort. Okay, second, there does not need to be a contractual relationship for a duty to be established, and third, manufacturers owe a duty to the consumers who they intend to use their product. So you see that even though there was no contractual duty between the manufacturer, okay, and then the ultimate consumer, okay, but nonetheless a duty was accepted here, established in this particular case. Okay, so manufacturers owed a duty towards the consumers who they ultimately intended to use their product. Okay, now this duty was not already recognized in earlier cases, as you have seen. Okay, so the question here, as I was telling you earlier, is that whether this new duty has been created by the judges, or has it been or is it based on some existing principles. Okay, so that is something that is very important. Okay, now you know that in the actual judgment they refer to some biblical ideas. Okay, of that I think it's the harm principle. Okay, thou shalt not injure your neighbor. Okay, so the harm principle is essentially what is referred to. I think it's discussed in the next para. You will see referring to Lord Atkin, who had said the rule that you are to love your neighbor becomes in law. You must not injure your neighbor. Okay, now here's the thing, this does not mean love in the other sense as we understand. Okay, love thy neighbor simply means that okay, you have certain duties towards your neighbor. So that being the harm principle, that you will not injure your neighbor. So even though there was no contractual relation between the manufacturer and ultimately the person who consumed it, okay, nor were they in physical proximity. So our idea of neighbor would be that someone you share territory boundary with, not that. So even the manufacturer is somewhere else and the ultimate consumer somewhere else, it's nonetheless a case of neighbor here. So you see that it's not used in that ordinary sense. Okay, so they based on this idea that thou shalt love thy neighbor. Okay, in law it becomes that you shall not injure your neighbor. So that's the principle. Now where did they get this principle from is a question that arises. Okay, is it laid down in any judgment? Well, if we look at the previous judgments, well, they came to different conclusion. Okay, in similar sets of fact situation. So again, the two explanations could possibly be there. One might say that, well, these principles are very much part of the system in which the judgment has been given. The others would say that, well, this is a creation of a new duty. Okay, so we have both these two different approaches. We will discuss later on in jurisprudence classes. So it further says that, who is my neighbor? Okay, so what would be the answer to that? So it says you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. So you see that this principle of reasonable foreseeability is here as well. Okay, then who is my neighbor then? It says that the answer seems to be persons who are closely and directly affected by my act, that I ought reasonably to have them in my contemplation as being so affected when I'm directing my mind to the acts or omissions which are called in question. So yeah, so as I told you that the proximity principle is also important, that when we talk about neighbors, okay, it's not just the people who are in physical proximity, okay, it's the people who I might through my action affect, okay, who my actions or my inactions might have effect on, okay. So they are neighbors, and along with that, another important principle that is being talked about is the reasonable foreseeability, okay. So what I do now might have some repercussions, that I could not have possibly foreseen, okay. So for example, if I were, okay, so for example, if I were taking my class here instead, if I had gone to the market, maybe if I were there, maybe if I was talking to one of my friends, maybe he would not have met with an accident, okay. So you see that I could not have foreseen that, okay, if I were there, if I were talking to my friends, maybe he wouldn't be somewhere else, and maybe he wouldn't meet with an accident. You wouldn't call this a case of reasonable foreseeability, okay. Another would be, for example, I drop something, okay, in the river, okay, a plastic bag, okay, not a good example, okay. I drop something in the river, okay, which floats all the way to like maybe 500 kilometers away, and which is eaten by some animal, and the animal dies as a consequence. Not a good example again, but that I could not have foreseen the exact way my action would have affected someone else, okay. Whereas, for example, if I threw the ball right outside the outside on the street, okay, there's a very high likelihood of my act of throwing the ball on the street it hitting someone. So you would say that in this particular case there is something called reasonable foreseeability. So in this case that we just discussed, so that from the manufacturer's perspective, that if the manufacturer does not take certain reasonable care, that will have certain effect on people who would ultimately consume the product, okay. So here the manufacturer failed to take the reasonable precaution which they should have taken to ensure that, okay, such half decomposed body of a snail is not there, okay. That they clearly have failed because it's there in the bottle, okay. So you can say that they have failed this particular test, okay, and accordingly they have also failed in the duty as well. So I think this is a very simplistic analysis of this of this entire case, but I hope you understood what the central issue here is, okay. That earlier the rule was that certain duties would be recognized only if we can say that, well, they exist by virtue of certain contractual relations, okay. If they were not by virtue of contractual relation, they will be recognized only in restricted cases, okay, not in others. So for example, fraud, and the other one is if the product is dangerous per se, but the person failed to provide necessary warning, okay. In other situations such duties were not recognized, but the Donoghue versus Stevenson is the case in which for the first time this new duty was recognized, okay. So one might say that, well, the duty always existed, this was merely reasserted in this particular judgments. Others would say that, well, this is a new rule of law which has been laid down. But whatever it is, it gives you a basic idea of what kinds of duties might be recognized by the judges in different cases. So do I make sense? Okay, did I make sense? As I was struggling to explain, did I make sense on this question of new duty situation? Okay. So the essence in this particular case is that, as you see, this duty, okay, was not recognized in previous judgments, okay. a new fact situation comes before the court. Okay, probably similar fact situation had existed earlier as well, as we discussed in the cases, but in this new fact situation the judges recognize a duty, okay, which the judges say that we owe to each other, to our neighbors. Okay, in this particular case the duty that the manufacturer owed to the ultimate consumer, even though there was no contractual relationship. So this is a duty which has been recognized. Now whether it is a new duty which has been created by the judges or whether it is a duty which already existed is the jurisprudential debate. Okay, the ones who say that, well, this is a new duty which has been created, they would say that, well, judges have decided this keeping in mind certain policy consideration. Okay, what would that be? So for example, if we do not hold it this way, what would be the effect of it in future? Okay, what would be the effect of deciding otherwise in future? If their decision is like that, then you will know that, well, the duty is being created right now. Well, judges do not do that, not explicitly in judgments, because in judges will refer to different case laws, different principles, and then decide the matter. So the other side would say that, well, judges are not creating the duty, they are deciding the matter, maybe not in terms of established rules, but certain principles that already exist in the legal system. So here the principle that we see here is that love thy neighbor, okay, which has been interpreted as, okay, so you shall not injure your neighbor. Okay, so whatever position it is, we see that a new duty situation which did not exist already has been recognized. Okay, is that clear? I hope this is clear. Then we'll take one more case.
Yes, sir.
Okay. So I'll send you guys link to another important case. These cases are important in negligence. Okay, they have evolved and changed. Okay, so let's look at another case. So for negligence, this is the first most important case. Okay, that laid down this idea of duty of care, like when do you owe duty of care towards your neighbors. Okay, with respect to that, another important case, okay, although this has been subsequently glossed over by other judgments that had come later on. So the next important case is Hedley-Byrne versus Heller. Okay, let's jump straight to the facts. Okay, what had happened was that Hedley-Byrne or Birne, whatever is the way you pronounce it, they were advertising agents, okay, placing contracts on behalf of a client on credit terms. Okay, so you might hear some noise from the bird sitting next to me. Excuse that, please. Okay, so Hedley-Byrne would be personally liable should the client default. So to protect themselves, Hedley-Byrne asked their bankers to obtain credit reference from H&P. So the reference was given gratis and was favorable, but also contained an exclusion clause to the effect that the information was given without responsibility on the part of this bank and its official. Hedley-Byrne relied upon this reference and subsequently suffered financial loss when the client went into liquidation. So details are not that important. We will just look at what the decision has been in this particular case. The court found that that H&P's, okay, the firm, okay, H&P's disclaimer was sufficient to protect them from liability, and Hedley-Byrne's claim failed. Okay, however, the House of Lords ruled that damage for pure economic loss could arise in situations where the following four conditions were met. Okay, so this is the question which was asked earlier. Okay, although this is not the deciding authority, this judgment is not the deciding authority, so don't rely on this judgment only to come to any conclusion. We'll look at other cases. So just this ratio would be of help for us. Okay, so I think which portion would be important for us is that, second. So if you just go to the conclusion, you will see that there the statement has been provided with respect to negligence. That it says in the second sentence, as you can see in the conclusion, that there have been considerable fluctuations in its application in the 50 years since the decision, okay, when it has been given, but it has opened the door to liability for negligent statements made by those in trust capacity and beyond into wider professional areas. So essentially the question is this, that okay, so when you rely on someone's statement, okay, someone who's supposed to know their business well, okay, and then someone makes certain statement, and based on that statement, okay, based on that statement which has been given, you take certain decisions, okay, and as a consequence, okay, maybe that statement which was given, okay, the statement which has been given, as by virtue of relying on that statement, you have taken certain decisions, okay, and as a consequence, you have suffered economic loss, okay, you have suffered economic loss. So in such situation, can you, okay, for such economic loss, okay, hold the person based on whose statement you had taken that decision, okay, can you make that person liable for such a loss or not? Okay, so that's a question which we are to find out, okay. So in case of pure economic loss of this sort, okay, can you hold someone liable for negligence? Ultimately the matter was decided in the case by the name Caparo Industries versus Dickman, okay, but before that we have another important case, okay, which will help us, okay. So more than Hedley Burn, you have to look at this another case by the name Annes Merton London Borough Council, okay. This is a case in which the question of pure economic loss was decided with little more clarity, but then even then ultimately it was like superseded by another case that is by the name Caparo Industries versus Dickman. So let's look at this particular case, okay. I'll share the link with you, just a second. So yes, I do not have, I cannot share the entire case with you, because that way we will not be able to deal with the whole thing. So here's the abridged version of the case, okay. So what is the fact here? So it's a case of a block of flats, okay, to which the claimants were tenants suffered from structural defect because of foundations which were too shallow. So the buildings, okay, with respect to which the tenants have suffered, okay, it suffered because of certain structural defect. Why did that happen? I do not remember the exact measure, okay. So the foundation which was supposed to be some 3 feet or something was instead 2 or 1.5 feet or something, okay. I don't remember the exact numbers here, okay, but because of that shallow foundation, certain cracks and certain defects emerged, okay, and leading to certain leakages from pipes and all that, okay. So as a result the tenants had suffered, okay. So whether the council, okay, was responsible, okay, who were responsible for inspecting the flats, okay, while they were being constructed, whether they could be held responsible or not, okay. So the question is whether this council, okay, not ultimately those who constructed, but the council who were responsible to oversee, okay, whether they had a duty of care that they owed to the tenants or not. That's one of the questions to be to be decided, okay, whether that duty of care, whether this duty of care, test of duty of care is sufficient or not. So this is what was to be decided in this particular case. The House of Lords held that the council did owe a duty of care, okay, because the entire construction was under their supervision, okay, and established a 2-stage test for duty of care, okay. So this is a development on the question of duty of care over that of Donogh versus Stevenson, okay. So they developed a 2-stage a test to find out whether there is a duty of care or not. Okay, so what is that? Okay, so you can see in the ratio that the first stage is that there must be a relationship of proximity, something we already discussed. Okay, there has to be a relationship of proximity. Okay, so my act, okay, my random act could have some effect on people, far away. Okay, so you cannot make one liable for every such act. Okay, so that is also there. That is the principle of reasonable foreseeability. So you see that there must be a relationship of proximity between the claimant and the defendant, and such that harm caused by the defendant's action was reasonably foreseeable. Okay, so these two elements have to be there first, and that there must be no policy consideration which restrict or extinguish the duty. So these are the two tests which were developed in this particular case. Okay, so what are those? The first is that the two parties here concerned have to be in proximity. So again, remember, when we talk about proximity, we are not talking about physical proximity. Obviously that matters, okay, but it need not be physical proximity in all cases. Okay, so what kind of proximity then? So it is that your action could have effect on people, okay, who are around you, whether you are able to reasonably foresee that such consequences could in fact befall upon someone. Okay, that's the first test, that proximity as well as reasonable foreseeability. And secondly, there must be no policy consideration which restrict or extinguish the duty. Now this is something that some jurists will be okay with. They will say that, well, this is the vindication of what we have already been saying, that judges in fact do decide matter based on policy considerations, whereas there are others who would say that, well, judges should not bother with policy, rather they should bother about what rights and what duties there are. Okay, so this is in a sense what the test has been laid down in this particular case. Okay, so I hope you guys understood the two different tests. Okay, the first part of the test talks about proximity and reasonable foreseeability. The second part is whether there must be no policy consideration which restrict or extinguish the duty. Okay, so the duty exists, but it was restricted, it was extinguished by some other policy consideration. Now, with respect to this, I told you the jurisprudential defect, disagreement, that exists. Okay, so the reasons provided in the judgments were the council's failure to check the foundation of the flats during the construction, foreseeably resulted in structural defect. There were no policy considerations to prevent the duty being owed. So this is what they, decided. Okay, that yes, the duty existed. Okay, it's not based on some statutory requirement, but based on the relation that they stood with respect to the people, the tenants here. Okay, the council stood in respect of the tenants, so they decided that the duty existed. And secondly, based on the second ratio, okay, the second test, okay, there was no superseding, okay, policy considerations. So they said that there was no such policy consideration that prevented the duty from being owed. So that's how they decided that yes, there was in fact some duty which was owed by the council to the tenants. Okay, so you see that in this particular case, what will be considered as pure economic loss? Because why is it pure economic loss? Because it ultimately led to some depreciation in the value of the property. Okay, that's the economic loss, isn't it? Okay, but it was in this particular decided that yes, in this in fact situation, the defendant owed a duty of care to that of the plaintiff. So did I make sense? Was I able to make sense in this particular discussion with this particular case?
Yes, sir. Yes, sir.
So, and then we have one, there are many other cases, okay, but I think I'll just leave you guys with, we are already 50, so you probably have another class. So I'll leave you guys with the name of another case. Okay, so just study this and we will discuss this in the next class. So this is the third case that we are going to discuss. So in this particular case, you will see to a lot extent the previous case, Ans versus Morton London Borough Council, that judgment was overturned to a certain extent. Okay, and then they gave you a threefold test. We will discuss what is the threefold test in this particular case. Okay, so if you guys have any difficulties, you can ask me.
Sir, the new students are supposed to do the only